returning officer did breach the law. So today she will begin hearing the arguments in detail for the appellant and for the respondents in this case. The respondents in this case are the returning officer, the chief elections officer, and the Guyana Elections Commission. We just came out of the courtroom where they're about to begin the session. And inside is the chief elections officer. He has not spoken publicly since, I believe, on Wednesday on the issue. He had promised at the GECOM command center, he had promised international observers and party agents that the process of verification as was started, which is the verification of the statements of poll in the presence of local and international observers, would continue. But as you have all witnessed, that process changed dramatically when that verification process was aborted. So you can tune in live to us here on the newsroom as we bring you the live audio from inside the courtroom of Chief Justice Roxanne George. For now, I'm Neil Marks reporting from the High Court.
There are 6 of them. The one by Mr. John Adams and the Deputy Chief Elections Officer, Mr. James Bond, an attorney at law, and Nicola Trotman, who is, I think, not a, I'm not sure. In any event, but it is, I think, well, certainly not a employee of GECOM, I don't think. I'm not sure. In any event, but the first point that I wish to make in relation to those latter 3 affidavits is that they all agree.
That is Myers, Bond, and Trotman.
Myers, Bond, and Trotman is that they all agree that the Section 84.1 process was interrupted at some time on the evening of March the 4th. The precise time is not important. And it was to resume on the following day. None of them dispute the evidence of Ms. Farag that when there was that interruption or suspension, however it is called, 421 out of the 879 polling boxes had been verified or ascertained, if you will, and that therefore there were 458 more to be dealt with. None of them dispute that. And therefore none of them dispute that insofar as the documentation in relation to the other 458 polling stations were examined, if you will, dealt with, I suppose is a...
And that therefore... That they were or they were not?
That they don't dispute that they were not.
Were not.
So that they don't dispute that they were not, and they do not dispute, therefore, that whatever was done in relation to those polling boxes was not done in the presence of the persons entitled to be present. There is no dispute as to that, as a matter of fact. What exactly happened after the suspension, or whatever happened in relation to the other 458 polling boxes is dealt with in Mr. Mingo's affidavit. And if I can ask you to look at paragraph 17 of his affidavit. He says at paragraph 17, I began feeling ill at around 11 a.m. and I went upstairs to rest. Before leaving to go upstairs, I instructed the clerks to continue the process.
This would be on what day, from your understanding of this?
This is on the 4th.
On the 4th.
Yes. He says that in the paragraph 15 just above that he is speaking of the 4th. So at 11 a.m. he went upstairs, and before leaving he instructed the clerks to continue the process and the senior clerk to supervise the process. He says, while upstairs my condition worsened, I had to be rushed to the hospital. And then he says, I was advised by Ms. Michelle Miller, senior clerk, and verily believe that the process did not stop since the clerks continued the process in my absence. And the observers and all party representatives were present. When I took ill, Georgetown was finished except 5 statements of poll that had queries, and we had East Bank of Demerara and East Coast Demerara to do. I was informed by Ms. Miller that in my absence, the clerks inputted the data for East Bank and East Coast Demerara. There was a complete input of all the data for District 4 at around 7:30 p.m. on Wednesday under the supervision of the senior clerk, Michelle Miller. that I was informed by Michelle Miller and verily believe that all the data for the District 4 was inputted into the computer by 4th March 2020. I was duly informed by the said Michelle Miller and verily believe that the information inputted into the computer, as I said, was extracted from the statements of poll for District 4 and into the computer onto a spreadsheet. Knowledge was utilized in previous elections and in all districts in these current elections. At all times in my absence, Michelle Miller, a senior clerk employed by GECOM, supervised the operation. And so he said, at that point I was ready to make an 84, but a request was made for reconciliation of certain things and so on. And then he says on the next day, so he says that the party was utilized in previous elections and in all districts in these current elections. At all times in my absence, Michelle Miller, a senior clerk employed by GECOM, supervised the operation. And so he says, 25, that at that point I was ready to make a declaration in accordance with Section 84, but a request was made for reconciliation of certain things and so on. And then he says on the next day, so he says that as far as he was concerned, the process was complete by 7:30 p.m. on the 4th of March 2020. And that he then returned the following day, and that is when he eventually, around 2 p.m., made the declaration of the votes recorded. Now, my lady, at first, when I first read these paragraphs, I thought what he was saying was that that process that Ms. Parag spoke about and everybody spoke about, which is that in the presence of the parties, there was an examination of the statements of poll and the votes recorded on the statements of poll, and everyone was looking at them together. I thought that is what he was saying was completed in the presence of the representatives. But when I take a look at the other affidavits that are filed on which he says that he relies, everyone says, including the Chief Election Officer, Deputy Chief Election Officer, that the process was suspended on the 4th of March to be resumed on the following day. And the Deputy Chief Election Officer also said that the use of spreadsheets was also discontinued after there were objections to the use of the spreadsheets, and that they went back to using the statements of the poll. And this is exactly what Ms. Parag said in her evidence. If you recall, she said that there was an objection at some point in time, and eventually they went back to using the statements of poll, but then it was suspended in the night of 4th March to be resumed the following day. So I said, when I first read what Mr. Mingo said, it suggested that I was contradicting his own witnesses. But on a second look, it seems that all he was saying that they were doing, if you look at paragraph 21, I'm informed by Ms. Miller that in my absence, the clerks inputted the data for East Bank and Demerara. There was a complete input of all the data by 7:30. That I was informed and verily believe that all the data was inputted into the computer. I'm duly informed by Ms. Miller and verily believe the information inputted into the computer was extracted from the statements of poll. So all that he's really, first of all he's really relating is what Ms. Miller told him that she did. He is not reporting, all he's reporting that she said that she did, and the other clerks, is to input information into the computer. And what he says that she did is to input it from statements of the poll. That by itself, first of all, my lady, it doesn't contradict the other witnesses that he relies on.
It does or does not?
Does not contradict, sorry, it does contradict, I'm sorry. To the extent that what he is saying is that the process continued and was completed on that day in the presence of all the representatives. That contradicts what his other witnesses say, and in any event it is hearsay evidence which you would be entitled to discount and to disregard in favor of the other direct evidence. I'm saying that, my lady, if in the event that that is what is intended to be portrayed, but on closer look it doesn't appear that that is what is being said. All that is being said is that Ms. Miller told him that they inputted the information on the computer. Now,
As distinct from doing additions of statements of poll per section 84.
that's correct. Well, what he says is that Ms. Miller inputted the data on the computer from the statements of the poll, as opposed to doing the process in the presence of the other representatives, whereby they can all agree, well, that is the correct figure that is coming from the statement of the poll. So we can deduce, milady, from this evidence that with regard to the remaining 458 ballot boxes, that the information that was inputted into the system or in relation to those polling boxes was done by Ms. Miller, a senior clerk, with the assistance of other clerks. And again, on the basis of hearsay evidence, of course, because we don't have Ms. Miller to give first-hand evidence as to exactly what she did and where she got the information from. But to the extent that this evidence is to be accepted and acted on, what happened is Ms. Miller took the information from the statements of the poll and inputted it into the computer with the assistance of other clerks. So you know that is what was done. So we have another element or another factor which we were not aware until 2 hours ago, when we saw the evidence of Mr. Mingo. And of course, it now raises the question whether there is another violation of Section 84.1, because Section 84.1 requires the adding up to be done by the returning officer, not by anyone else. And of course, this is not a matter that we could have addressed in our written submissions. But, my lady, that is not a function that the returning officer can palm off to someone else. It is a function that he must perform himself, according to the terms of Section 84.1.
But I was looking at 86.1 though.
Yes, my lady.
86.1.
Yes, my lady. 86.1 says that, no person shall be present except the returning officer and such other election officers as he may appoint to assist him.
Yes, sorry about that. 86.1
Yes.
speaks to the RO or anyone else who he requests to assist him.
But not anyone else, my lady, election officers. And when you go to the definition of election officers in the Act, it speaks of the chief election officer, the deputy chief, a returning officer, a deputy returning officer, an election clerk, a presiding officer, an assistant presiding officer, and a poll clerk.
Just a minute, let me...
That is in the definition section of election officer.
I have the definition. I just need to check my 86. Yes, 86.1.
Yes.
That the RO can, in his discretion, decide which elections officers will assist him.
Yes. Ms. Miller is described as a senior clerk employed by GECOM, not an election clerk. And of course, election clerks and election officers generally are specific office or officers specific to an election, and they are required before they take up office to take an oath.
All right, point taken.
Much obliged, my lady. And so in that regard, my lady, I'd refer you to the case of Attorney General against Monco. It's a decision of the Court of Appeal of Tanzania. And you will see in that case,
Which case is that, sorry?
we handed it up separately, my lady, just a short while ago.
Ah, that's what just came in. All right. I have the other case, Singh and Nehru.
No, not that one.
No, I read Singh and Nehru, which seemed to have had some dicta on that.
Yes, my lady.
AG and Moku. AG versus Monku.
Monco, M-O-N-K-O.
Yes, in this case, in brief sense.
In brief, it says, my lady, that where the legislation requires the returning officers and assistant returning officers to do a ballot count, enumerators who are appointed to assist the returning officers could not do it, and therefore their doing it was a violation of or constituted non-compliance with the legislation. And if you look at page 215 of that judgment,
Yes.
at 215 at around letter B, it says, however, as Mr. Aliwike submitted, the provisions of section 73 are clear and unambiguous. It is there clearly stated that before the returning officer and the assistant returning officer proceed to count the boxes, they shall open each ballot box, take out the ballot papers, count them and record them. It is not provided that the enumerators may assist in the performance of these acts, and we have no good reason for reading such provisions into this section. It may very well be that the framers of this section regard the initial counting of the ballot papers as a crucial and strategic point in the counting process for checking against possible mischief. And for that reason, they require the returning officer and the assistant returning officer to handle the situation personally. We are therefore constrained to hold that the trial judge was justified to take the view that the counting of the ballot papers by the enumerators was in non-compliance with the provisions of section 73. So we say that he could have two things, Milady, I want to make it clear. He could have appointed election officers, a poll clerk, an election clerk, a deputy election officer to assist him in the adding up of the votes on the statements of poll. He could have done that, but the person who he appointed does not fall within that category of officer. That person is a senior clerk employed by GECOM. But even if she was an election clerk, let us say, then all he could have done was to appoint her to assist him in the counting. That's all he's permitted.
Does that mean that he had to be present if you appoint somebody to assist you? Do you still have to be actually present?
Well, you have to do some sort of supervision. What he says happened there is that he was absent, and the entire process was completed in his absence by the senior clerk, my lady, and other clerks under her supervision. So he appointed her, and she got the assistance from other persons. We don't even know who they are. As the Tanzanian case indicated, my lady, the whole idea of selecting particular persons who have taken the oath before they take up their functions is to reduce the possibility of mischief taking place. Now, so there's that additional point. But even if, my lady, we were to proceed on the basis that Ms. Miller could have assisted Mr. Mingo in his absence, even if we get past that point, or they're able to get past that point, my lady, we still have the problem that that counting was done in the absence of the representatives for 458 polling boxes. And we have the question as to whether what they actually did was to add up the votes from the statement of poll. And my lady, in summary, you will have seen from our submissions that what we say is that section 84(1) cast in mandatory or imperative language, the returning officer shall, in the presence of such persons entitled to be present, ascertain the total votes cast in favor of each list in district by adding up the votes recorded in favor in accordance with the list. So the process is taking the statements of the poll, looking at the votes that are recorded on the statements of the poll, adding them up. That is what you're required to do. Now, my lady, the other bit of evidence that has not been disputed in this case is that, as Ms. Parag has deposed in her paragraph 5, that they got the carbon copies of the statements of poll from the presiding officer as provided for under the legislation. And they did a tabulation themselves, that is, Ms. Parag participated in the process of doing the tabulation, of adding up the votes on the copies of the statements of the poll that they had. And they produced a table showing exactly what that count was in relation to District 4. Now, as I put in the submissions, my lady, the count done by Ms. Parag, which again is not disputed, differs from the declaration that is done under the hand of Mr. Mingo, but as we found out was actually done by Ms. Miller. The calculation is done by Ms. Miller. It differs by an amount of
But Mr. Mendez,
Yes,
Mr. Mendez, I would like to caution, because I'm not getting into any counts. I'm not getting into any of that kind of data. So, and I will explain later when I have my questions that I have to ask you. Well, not explain, but it may become clearer. So, to be very honest, I'm not concerned with whatever data has been produced by Ms. Parag or anyone else. To my mind, the narrow issue is whether or not the addition of the SOPs was done in the presence of persons who were entitled to be there, and whether the declaration was done in the public manner as required by Section 84. To my mind, that's it.
My lady, well, as far as that is concerned, that has been established as a matter of fact that it was not done in the presence of the representatives. But the other aspect of our case is that the other obligation that is imposed on the returning officer under Section 84(1) was not performed. That other obligation was to add up the votes on the statement of poll. Now,
you're saying Ms. Miller did it in the end?
That's one aspect of it. One aspect is that he did not add it up as the law requires. Ms. Miller did. That's one. I've dealt with that already. But I'm saying whoever did the actual arithmetic did not add up the votes on the statement of poll. They got the information from somewhere else.
Well, Mr., I don't accept that the affidavit so disclosed.
Well, my lady, could I address you on whether the affidavit is so disclosed?
I don't think that that's an issue that really arises, given what, from the application, the parameters that I understand the case is wrong.
My lady, I have put those submissions in the written submissions, and
I skimmed them. I skimmed through them. Yes, I did read them, and I'm very concerned that that is not an issue for this court.
My lady, all I can say is that I rely on the submissions, and I rely on the submissions specifically in relation to that point.
Yes.
So the question of law which arises then, milady, is whether, because as we anticipated and my learned friends have engaged that point directly, it is whether the failure to comply with Section 84.1 in the respects that we have identified are such as to lead to a declaration of invalidity and to the other orders that we seek. Now, my lady, I have set out in great detail the law in relation to this particular aspect of the matter. We have set out in great detail why Section 84.1 is to be considered using the terms that are now out of fashion, mandatory, but it's a shorthand way of expressing what the law requires the court to find, which is that Parliament intended that if you did not follow the provision, that the act can be declared to be invalid. And the major consideration that the authorities indicate that my lady ought to take into account is the consequences of the breach that has occurred and the consequences of a declaration of invalidity. In other words, will prejudice be caused to anyone by saying that the returning officer must now do the process as is required by Section 84.1? That is to say, he must do it himself, and he must do it in the presence of the persons who are entitled to be there. And of course, he must do it by adding up the votes on the statements of poll. Will any inconvenience with anybody's rights be prejudiced? And we respectfully submit that there is no indication that anybody would be prejudiced by such an order. We say that because, first of all, what such an order would do, that the electoral process is carried out in accordance with the law in a way which would ensure that the public has confidence in the process, that it was done transparently and not in secret, and therefore they can have confidence that the actual function that was to be performed under Section 84.1 was actually performed, and not have to rely on, as it turns out now, a senior clerk and other clerks and the function that they did behind closed doors, not even under the supervision of Mr. Mingo, who was not there. That cannot cause any inconvenience to anyone. On the contrary, milady, a failure to require that the process be done strictly in accordance with 84.1 will lead to distrust in the process, will lead to suspicion, and will lead to a lack of confidence in the results that are eventually declared. So there's really no good reason why an order ought not to be made in these circumstances. And of course, my lady, making an order that requires the process to be completed in accordance with 84.1 would obviously further the objects of the legislation, which is that that process ought to be carried out transparently and out in the open. So actually there are no downsides whatsoever to the orders which we require you to make. My learned friends rely on the judgment of Chief Justice Bernard in the Hamilton case, in which the Chief Justice said, on the one hand, that she thought that the provisions of 84.1 were directory, but at the same time, as she said that in almost the same breath, she says that that does not mean that this is not a duty that must be carried out. She made that plain. It is a duty that must be carried out. And at the same time as having said that it was directory, she nevertheless made the very same order, which is the order that we seek in these proceedings.
Just a minute, sir.
With by the judgment says that they're directed.
Yes, Mr.
Yes, my lady. So that there's a bit of confusion coming out of that judgment, if I may put it that way. But we ask you to, of course, consider the authorities that bind you as far as the approach that you are to take in the assessing whether Parliament intended that invalidity should result. And of course, those authorities and our arguments are set out in copious detail in our written submissions, and we of course rely on them. Now, my lady, the learned friend in his written submissions says that because of the order made by your brother last Thursday, which, as I think you noted on the last occasion, were in final form, although they ought not to have been, that creates an estoppel, and that prevents us from seeking any further orders in these proceedings. It's an unusual submission because, in effect, what my learned friend is saying is that we are bound by the orders that have already been made on March the 5th. And if that is what he's saying, then we gladly accept. So, and if so, we are waiting for him to comply.
I'm going to find out from Mr. Boston what he really means by that.
Yes, I'm not clear, because if he's saying that we are bound by that order and therefore we can't proceed in these proceedings, well, then get his client to comply and everybody will be happy, because that order says that he must comply with section 84.1. So I'm not clear as to exactly what else I'm to say in relation to that argument, my lady. So, I've really gotten to the stage where I can ask if there's any clarification that you need on any of the points that we make in our submissions.
Yes, I do have some queries. There evidence that Mr. Ramson sought a recount.
Yes, my lady.
Would this tend to suggest that he accepted that there was a declaration on the 5th by Mr. Mingo? Because the 84 2
Yes.
is premised, in my view, on there having been a quote-unquote declaration. So you have until noon of the next day to, in effect, challenge it.
Sure. Yeah,
so that's my query is whether that is a tacit acceptance that the declaration was made.
My lady, I think after having regard to Mr. Mingo's evidence and the attachment of a document that bears an official stamp on it, and other statements by other witnesses who said that they heard him make a public declaration, we are not in a position to dispute as a matter of fact that that is what he did. Whether the declaration that he made is a declaration done in compliance with section 84.1, of course, is what we have been advocating before you over the last few days. So if your question is that a tacit acceptance that Mr. Mingo physically
Well, not physically.
Or
He
as a
made
matter, if we should put it to make a declaration, the answer is yes, he did do something.
But my question is whether it amounts to tacit acceptance, not just the fact that he did.
The legality of it, my lady?
Yes, because you're going to your 84.2 step.
Well, my lady, it can't because, first of all, if it is that a declaration under Section 84.1 is made unlawfully, until it is set aside by a court of law, members of the public have to assume its legality and act on it. It is lawful until the court says otherwise. I think those are the basic principles of law. It might be voidable, but as yet it is not voided. And therefore, Mr. Ransom would have been walking on very dangerous ground if he decided, well, I'm going to ignore it because as far as I am concerned, it is invalid, and not make the request within the 24 hours by 12 o'clock the next day, and only to find out later on that the court says, no, it is perfectly valid. And then he would have lost the chance to get into his mind as to exactly what he thought of the virus of the declaration may have been. It really doesn't matter at the end of the day. It certainly doesn't bind everyone else from challenging the declaration on the basis that there has been non-compliance with Section 84.1.
The next question I have is, what is meant by Latin spirit? I know it's something that we seem to like to use now, but I mean, when I look at the mandatory injunction order, which I think I mentioned on the previous occasion, so it refers to, and even before we get there, one of the other ones has it also.
Milady,
yes.
We will not be asking
you them to comply with the Latin spirit.
Yes, milady. We will not be asking you to continue an order with those words and spirit, because of course that would lead to a great deal of uncertainty. But I think that what was intended is that you have to, one would always have to interpret the legislation in accordance with its purpose.
I understand that, but to have this Latin spirit business,
to include it in an order, my lady, I agree with you that it
so it is
ought not to be included. Yes, and therefore that ought to be left out.
All right, so that's it. We have been discussing Section 84 of the representation to people after, but in the application, there's reference to the declaration being unconstitutional. I was wondering unconstitutional in what way? What provision is being breached, or is it just a...
Milady, we haven't made that submission in the written submission.
Okay, so that aspect of it is not...
Our case is focused on Section 84.
Very well. I'm just going to what was asked for.
I appreciate, Milady. You appreciate, Milady, that these papers were prepared. First of all, we had 72 hours in which to prepare it.
Don't worry, in Guyana they love to throw in the Constitution in every single thing. That's why I'm asking.
Yes.
So everything has the Constitution in it. And it could start from Article 1 and go all the way to Article 250, whatever it is, 59 or thereabouts. And somewhere in between all of that, the court is supposed to just figure it out. So that's why I just was wondering if there was a specific provision that you were going to like.
I think it was put in out of an abundance of caution.
Well, I think it's a bit confusing. Now, Ms. Parag and also Mr. Holidar referred to what occurred, well, in brief, that in the other 9 districts, but I don't get the sense of what occurred in the other 9 districts that, separate apart from the 84, for the simple reason that these words, verification and reconciliation, I'm trying to understand what they mean and what provides for verification and or reconciliation. What does the applicant mean by that?
Milady, whatever the applicant meant when he said that in his affidavit is of no moment. What is of importance?
Well, no, but I'm trying to understand, because remember, the plank was or is
yes,
that there has been no verification and or reconciliation.
yes.
So I'm just trying to find out what provides for this and what is meant by that.
Lady, what is meant is exactly what is provided for in section 84.1.
That is just the adding.
That just ascertain, the words that are used in section 84.1 are to ascertain the total votes cast in favor of each list by adding up the votes recorded in favor of the list.
Yes, but you see, verification and reconciliation tends to suggest there's some kind of process that has to be done.
Because what happens in practice, milady, as I think the evidence indicates, is that the returning officer would produce his or her statement of poll, that is the original, and the representatives would have their carbon copy of the statement of poll, and they would be able to reconcile the figures that the returning officer has with theirs. And of course that is part and parcel of the reason why it's done in public in their presence and not in secret, so that you can be assured that the figures that the returning officer is using is the same figures that the representatives have. So I think the word verification and reconciliation is being used in that context.
So might I just ask you this, because there are 10, my understanding,
yes,
is that there are 10 political parties, no, 10 political parties
yes,
who would have contested in District 4.
yes.
Now, is it that the returning officer, in an exchange with any one of these members or representatives, I should say, of political parties, is he then to get into offending and proving, as we would say in Guyana? Because one would say, well, my SOP, because clearly there's some dispute.
Yes.
My SOP has 50 votes, the other one says, no, mine has 40, another says mine has 30.
Yes.
Wouldn't it be that the returning officer then has to rely on the SOPs that he has that were sent to him?
Yes.
And not get into offending and proving, which may end up in some discord in terms of getting this addition done?
But I would think that he would have to resolve whatever dispute there is there and then.
Okay, so for Arrow to resolve.
But the point is that he would resolve it openly. He would resolve it after, of course, taking into account what the objection may be.
Because when I consider that the RO may say, well, I got statements of poll from the presiding officers pursuant to Section 83.
Yes.
And I'm relying on these
Yes.
Statements of poll. And then we get to Section 84.2, which clearly contemplates that there's some kind of disagreement,
yes,
and that is the dispute mechanism, as distinct from getting into a quote-unquote brawl or fight with a returning officer, who both sides decide, each side is deciding the other is being belligerent.
Yes.
And so both sides are holding on to their position.
Yes.
So that's why I'm asking that, you know,
so let me
in the language of the verification, the reconciliation, yes, you have many political parties,
yes,
each one having, according to the legislation, can have many representatives.
Correct.
There. And based on what I saw in the affidavits, there clearly was a lot of discord.
Yes, so let me give an example. Let us say that the original of the statement of the poll looks like 175. And the carbon copy, although I'm not too sure if it is actually, yes, I think it is actually carbon copies that are given to the parties, looks like 178. So the returning or vice versa, 178, 175. So there's a dispute as to whether it is a 5 or an 8. Now that is something that of course the returning officer looks and says, well look, I'm seeing an 8 here, it might look like a 5, but it maybe it's because of the carbon, and he says I'm going with this with the 8, or it may be that his the copy that he's gotten, there may be a watermark. Water may have fallen on it and smudged the figure, and therefore he looks at the carbon copies and he says, well, seeing that all 5 of you all have the same figure on the carbon copy, I accept your figure, and so on. So those kind of things can be resolved. If you have,
but then equally he could say I'm sticking with what I have.
he will stick with what he has or with what he accepts.
I'm just saying, trying to.
No, he will have to resolve those disputes.
Exactly. Okay.
But of course, there's also the process in section 84(1)(a), where if errors or mistakes are discovered, then you call in the presiding officer, and the presiding officer will assist to resolve that dispute, as has occurred in some instances in this particular instance. But where you have, for example, large differences...
That's 1AB.
Yes, 84.
1AB.
Yes.
But of course, 1AB presupposes that there's an acceptance that there's a mistake.
Precisely.
Okay, but at the end of the day, it would be for the returning officer to make that decision.
Yes, my lady. And once people are acting in good faith, of course, you move forward, you record it, and you go to the next statement.
Go to the next one.
But where you have, I can imagine where you have a large number, a large difference between the original statement of the poll that the returning officer has and the copies that the other parties have, then the way that would be resolved is through the recount of the actual ballots.
Yeah, but then that will have to come after.
That comes after.
That's what I'm saying.
Yes.
So then you go to 84.
That's
exactly.
84 too.
So that the returning officer might say, listen, I'm not going to get involved in this fight over how much and how much not.
Exactly.
I'll stick with the statement of poll that I have.
That's right.
And if you want, you can have recourse to 84 too.
Yes.
Okay, so, I just wanted to
so lady, what would happen in this, if you were to make the order then, and those disputes arise, if those disputes arise, and the returning officer, having done everything in the presence of everyone, comes back with figures that the parties are not satisfied with, then you go to 84-2 and it's resolved in that process.
Because I was just trying to figure out what was the role of the persons who were entitled to be present, but you've answered the question.
Yes, yes.
And just finally, I think you've answered it based on the narrative, the factual narrative.
Yes.
I think somewhere at the end of Ms. Parag's and Mr. Holodar's affidavit, because he's relying on what she said, but anyway, that the injunctions were served before the declaration, but there is no really clear evidence of that.
The injunction was never served on him. At least we did not serve it on him directly. He may have seen it after, but they were made public. But
but I'm just going to what the affidavit actually said.
Yes, well, we have made any issue about that, Melania. Melania, we don't say that it was served on him before he made the declaration. We don't say that.
You don't say that, okay. Yes, that's it. Thank you very much, Mr. Mendes.
If I may have 1 minute. Thank you very much.
Yes, Mr. Boston.
CJ, it is respectfully submitted that the RO can adopt what methodology he decides that he will pursue to come up with the results. Now, he can sit with the persons who are entitled to be there, and he will go through the statement of polls, or he can prepare a spreadsheet from the statements of poll, and thereafter he can declare what the amount of votes received by the list of each candidate. As the evidence revealed, Ms. Parag, this case is hinged on a person's affidavit, Ms. Parag, who has no authority to be there. She is not one of the persons that Section 86.
Mr. Boston, where in your affidavit has any of the affidavits is it so stated that she was not a person entitled to be there?
She is supposed to establish that status.
Mr. Boston, you are saying she is not a person entitled to be there. Where in your affidavit have you so claimed? Not your, when I say your affidavit, sorry, the affidavit of the respondent.
In the affidavit of Ms. Mears and Ms. Mingo, we did not allude to that factual matrix.
So, case is hinged, you're saying the case is hinged on Ms. Parag being a person who is not hinged on evidence of Ms. Parag, who is not a person entitled to be there.
But assuming, without admitting that she was entitled to be there, the election, the returning officer is duty bound to rely on the statements of poll that were remitted to him from the various stations in District 4. He does not have to go through a period of resolving discrepancy that arise in relation to the polls that he has, the statement of polls that he has received from the various districts, and what Ms. Parag or other members of the political parties say they have. The legislation has provided a remedy for that, and that remedy is Section 84(2). You ask for a final count. Because there is evidence that there was discrepancy all along the line, and the discrepancy led to the objection. So they're saying it is the function of Mr. Mingo to sit down and listen and resolve. That Section 84(1) has not provided for any such resolution. The remedy, if you are dissatisfied in relation to what Mr. Mingo was reading from the statement of polls, he said he has received from the various districts, you have to ask for a recount. And that is why Mr. Charles Ramsden Jr. purport to invoke Section 84(2) to have that remedy. But there are disputed facts whether Mr. Ramsden was indeed.
I don't think we need to get into that aspect either, and I said this also in my ruling on Sunday. Whether or not he was nominated or accepted as a counting agent is ex post facto. Issue is whether at the time of the adding of the statements of poll, it was done in the presence of persons entitled to be there. And well, I didn't ask Mr. Mendez, I must mention, I don't think we really got into the issue of whether there was a public declaration, because that was also initially part of the application.
There is evidence from Mr. Mingo that he declared the votes for the list of each party that were sent to him. There is no evidence that he did not do the final count before the declaration was made.
Where he has his affidavit. What has he said about that?
All there is evidence, he said that the senior officer inputted the information from the various statements of oath. But there is no evidence that she counted them.
That she
counted the polls that led.
The SOPs.
Yes, that SOP that led to the declaration made by him.
Here is his affidavit. So, but what's the evidence that he counted them? If there's no evidence that she counted them, where is the evidence that he counted them?
We will, inasmuch that it has not stated expressly, we will have to accept the presumption of regularity because he's the man who.
Well, he should have said so, don't you think so?
I think he should have said so expressly, but the fact that he has not said so expressly doesn't negate the fact that he did not do it.
But Mr. Boston, he is the person who has the duty and the authority. So shouldn't he have deposed to that, rather than just leave it at large and say, rely on the presumption of regularity?
He alleged that he has complied with Section 84(1).
How?
But there nobody has said he did not count, and section 84(1), he has
Okay,
to.
nobody has said that he did not.
Yes.
But since he has a sworn document, why can't he say what he did? So we're not going to the negative, we go to the positive.
Yes, he could have said so expressly, but he didn't say so.
Well-
But he said he has complied with section 84(1). Now, I further submit that even if he has not complied by doing a count in the presence of the persons who entitled to be there, it does not invalidate what was done, nor does it invalidate the declaration made by him. On the last occasion, my learned friend quoted extensively from Justice Bernard in Joseph Hamilton and GECOM et al. Number 40 M of 2001. And she, the learned Chief Justice, had to consider section 84(1) of the Representation of Peoples Act. And this is what she said at page 15. Overall, I think those section 84 of the Representation of the People Act is not mandatory. The provisions impose a duty on the returning officer. And although in my view, non-performance of this statutory public duty may not render acts done in performance of this statutory duty null and void, as was stated in Normandy, it is a duty which is binding and should be carried out. This must have been the intention of the legislature, and it should not be ignored. She concluded that section 84(1) is directory. However, there is a line of cases which establish the principle that where there is non-compliance with a provision of law is directory in nature, substantial compliance would meet the requirement of the law. We are saying there was substantial compliance, and I will come to those facts. In Regina and
Just before we get there, Mr. Boston, but you said that Hamilton is wrongly decided.
So when I say Hamilton is wrongly decided, I am saying Hamilton is wrongly decided if Hamilton decides that during the conduct of an election, an intermediate act can be taken. That is, you can come by way of a writ or for judicial review. That means, if that is what she meant, it is wrong. It's not her interpretation of section 84.
Okay, very well. I just was making sure that, when you said it was wrong, that everything went.
No. I made that distinction on the point in limine before.
I was just making sure, because, when you say it's wrongly decided, and then you're relying on it for another point.
No.
I was just making sure
that if
everything
it purports to speak to a particular state of affair.
Yes, I understand.
Now, in the case of Regina and Sonny Fee and another,
Is that produced? It's laid over?
Yes, it was laid over. Oh, my learned friend has went to town on it. And I will deal with other
Could you
passages.
spell it, please? Because I'm not picking it up very clearly through the mic.
That in Regina and Sonny Finney and another,
Yes.
at page 349.
What, could you give me the citation, please?
It is 2006 AC 340 at page 349.
Yes, and you said you're reading from?
Page 349, I'm reading from Lord Steen at judgment at paragraph 14, where he has made a bold attempt to remove from the whole distinction of directory and mandatory. He said a recurrent theme in the drafting of statutes is that Parliament casts its command in imperative form without expressly spelling out the consequence of a failure to comply. It has been the source of a great deal of litigation. In the course of the last 130 years, a distinction evolved between mandatory and directory requirements. The view was taken that where the requirement is mandatory, a failure to comply with it invalidates the act in question. Where it is merely directory, a failure to comply does not invalidate what follows. He said there were refinements, and he, in his judgment, relied on the judgment of Lord Aylsham to set out his refinement. For example, a distinction was made between two types of directory requirements, namely the requirements of a purely regulatory character, where a failure to comply will never invalidate the act, and two, the requirements where a failure to comply would not invalidate an act, provided that there was substantial compliance. A brief review of the earlier case law is found in Wang and Commission of Inland Revenue. And he cited Lord Slane judgment in that case. In Sonny G, now, Lord Steen at page 349, a continuation, which was cited extensively by my learned friend.
That's paragraph 15.
Paragraph 15.
Okay, you don't need to read
Yes,
it down.
but he talks about a new perspective. Now, then he went along at page 353. He cited that this new perspective that he has gleaned from Lord Aylsham and
Which paragraph on page 353?
on page 353.
Which paragraph?
Paragraph 22. He was speaking, he said in Canada, there have been developments along similar lines. The starting point is British Columbia Attorney General versus Canada Attorney General. In Re and Act respecting Vancouver Inland Railway, the mandatory and directory distinction was strongly criticized. For the majority, Ikogusi J observed at page 123, courts tend to ask simply, would it be seriously inconvenient to regard the performance of some statutory direction as imperative? My understanding is that 7 of the Supreme Court judges were agreed on this point, with Lehman CJ and McLaughlin dissented. So in as much as there are 7 judges who seek breaking new ground to go to the new perspective, there are two who still have a preference for the old order of mandatory and directory. Lord Carswell, who also sat in this case, this is what he had to say at paragraph 61.
So you're moving to paragraph 50?
Yes, Lord Carswell. Inasmuch as what the due perspective that Lord Steen cited, that Lord Aylsham and the others, he said the distinction between mandatory and directory provision, which was much discussed in judicial decisions over many years, has gone out of fashion and has been replaced, as Lord Steen has said, by a different analysis directed to ascertaining what the legislator intended should happen if the provision in question were not fully observed. This is what he said: I do not seek to question the correctness of the altered approach to this, but I do feel that principles inherent in the rejected dichotomy in some cases offer assistance in the task of statutory construction. So that the principles inherent in the rejected dichotomy, he says, still is useful.
Yes, but applying all of that, how is that to be applied to the case?
No, I'm saying that.
So you're saying you should still apply the mandatory directory dichotomy? Okay.
And this is what he said at 65. The traditional consequence of finding that a provision was merely directory was that substantial performance will constitute a sufficient compliance with the statutory requirement. This concept can be more readily applied where a statute prescribes an exact method or sequence of carrying out specific acts, or a time within which they are to be performed. A minor and insubstantial deviation from the requirements will not make the resulting proceedings invalid. So he still feels that there is still some utility in the whole dichotomy, directory and mandatory, in as much as Lord Steen, Lord Aylsham, Lord Slynn, and the Canadian court as going to a new perspective.
Yes, but what I'm trying to find out from you is how is that applicable to this case?
I'm saying it's applicable.
How?
In this case, because the evidence would have revealed a substantial compliance. The arrow sat with the
Substantial compliance with what?
with section 84.1.
In what way?
No, from Monday night in his affidavit, he worked with them.
That's Mr. Mingo.
Yes, with the political parties, dealing with the statements of oaths that were said to him. The same state of affairs continue on the 3rd.
Yes.
The same state of affairs continued on the 4th to a limited extent when there were discrepancies And after discrepancy led to a rowdy and disorderly behavior by persons in GECOM Command Center. He resorted to make his declaration from the spreadsheet. If Your Honor recall that from the affidavit, it was agreed that the spreadsheet will be used. That was
yes, but in one of the affidavits it's also stated, on which Mr. Mingo relies, it is also stated that it decided to discontinue the use of the spreadsheet.
Yes. I am just
so if he went back to the spreadsheet, well then that might be a problem. Because he's saying we were going along, we used the spreadsheet. There was some disagreement about the use of the spreadsheet, and it would appear that the decision was taken not to use it. So if you are saying that he made his declaration based on the spreadsheet, that the respondent's evidence discloses there was a decision to discontinue the use of such spreadsheets, then how could he go back to that which they sought to discontinue?
But he was entitled to go back there because the issue that gave rise to the discontinuance of the use of the spreadsheet, if it were due to the fact that the PPP supporters who were there, when he calls a score from his spreadsheet, they said, not at all, we don't have this. It was agreed by the CEO, well listen, I will extract about 3 statements of poll and let us see what happens. That was rejected. So what was there any need for him to sit down to keep disputing the issue of discrepancy with members of the political...
But that is why I asked Mr. Mendez about that. Because one can go back and forth with
yes.
10 political parties.
Yes. And
so that's why I said at the end of the day, Mr. Mendez did concede, if I might use that word, that it would be for the returning officer to resolve one way or another. Either I'm going to agree with what is being advanced to me, or I have my statements of poll that I got from the presiding officer and I'm sticking with what I have. You could do whatever you want to do later, but I'm sticking with what I have, because I can't deal with 10 people yelling at me, because all 10 might have something different. So I'm not dealing with the 10 of you. Yes, you've raised your concerns, they're duly noted, but I'm going to stick with what I have in front of me. You can deal with everything later. That's my understanding. But the fact of the matter is that it would have been done in the presence of persons entitled to be there.
So I don't think there can seriously be any complaint that there was not a substantial compliance. Why do I sit to resolve dispute and here this doesn't correspond?
That's what I'm saying. So he moves on. He says, well, I noted what you said and I'm moving on.
Section 84(2) gives you the remedy.
Exactly. So I think that there is now accepted. But the question is whether there was a continuance of the process that allowed persons to say, well, I have a different number. for the RO to say, well, you have a different number and I'm sticking with my statement of vote. The question is whether there was compliance in that regard.
Of course, with the greatest respect, there was compliance, and
but Mr. Mingo wasn't there for a good bit. He's relying on the evidence not the evidence. He's relying on what Miss Miller told him. Miss Miller doesn't have an affidavit here.
Miss Myers was there, and Miss
Myers also said she left.
But we do not even have to go to Miss Myers' affidavit. Those were the facts narrated by Miss Parag. She narrated what occurred over.
And Miss Parag said that there was a gap. There was a gap. And the affidavits of Miss Myers and Miss Trotman indicate that, there it is, paragraph 30 on Ms. Trotman's affidavit, paragraph 41 on Ms. Myers' affidavit, which seem to contradict Mr. Mingo's affidavit, because they seem to be saying whatever reason, staff was tired and so on, there was a decision to stop the process at some point in the night of the 4th, and that there was to be resumption on the 5th. But Mr. Mingo doesn't say that.
But Miss Adams, Nicola Trotman was speaking as to facts within her knowledge.
I understand that, but so then Miss Myers, who was the deputy CEO, when she said that there was to be a resumption, that's around 12 noon, which would have been on the 4th, a decision was made to resume the process. Sorry, that would be on the 5th. A decision was made to resume the process. From her affidavit, it tends to suggest that the process she's talking about, the addition of the SOPs.
Yes.
But Mr. Mingo's affidavit doesn't speak to that.
But she is the deputy, and
I
she
understand, but he is the returning officer who then said, I made a declaration. So, in relation, I'm just going to your substantial compliance. So he says, I came on the 5th and Miss Miller reported to me. I ascertained whatever I had to ascertain, and I concluded that I could make the declaration. But prior to that, we have the witnesses saying there was supposed to be a resumption of the tabulation. But he doesn't speak to that at all. And remember, he was absent for a while. He left Miss Miller in charge.
But even if Miss Miller says there were to be a resumption of the process, Mr. Mingo can, in his deliberate judgment, decides that no useful purpose can continue. I have tried in a substantial way to have this, but no useful purpose can be achieved. There's no utility in this, and I have the figures, and I will declare it. This is not a case where Mr. Mingo was ambushing anybody. Mr. Mingo was a willing participant with all the parties going along up to 3 a.m. from the night of the poll to 3 a.m. on Tuesday morning, come back. on Tuesday morning, come back on Wednesday morning, and was working. Will you not call that substantial?
Well, I don't know, because you see, at that stage, about half was left to be done.
It does not matter.
That
Because
half was left to be done?
it does not matter for the simple.
If it was like maybe 10% or something, and I don't want anybody to hold me to that, please. But, you know, half, we had 400, according to the evidence, 421 SOPs had been dealt with, and there were 458 left to be dealt with.
I think it is a mischaracterization if you are relating substantial performance to number of polling stations that were counted. Certainly it is a mischaracterization of what is substantial performance. Substantial performance has to do with its act in moving the process forward. They would have suffered no harm by calling for final recount. You're saying I'm with you all night, Monday night till about 3, Tuesday all into the night, Wednesday, Thursday, and you are going to say there is no substantial performance because what were not dealt with was 558 statements of poll. They had all the chances on a recount. That is the remedy that the legislation has given them. Now you have not made use of the legislative remedy, and you come.
All right. So let me ask you this: what is the reason for having the provision, the phrase "in the presence of persons entitled to be there"?
What's the reason of having the provision? Because it presupposes that everything should be going well and not several discrepancies. It presupposes that things are going to be going smoothly. Yes. He must be able to function.
No, I'm asking you, why have that particular provision?
As I've said, Chief Justice, that provision was to enable a rational interaction. It was to enable a rational interaction with the returning officer and the representatives or counting agents of the political parties. But you have gone 4 days and it turns out to be an irrational interaction. The evidence, which all of the affidavit, Ms. Parag, Mr. Ransom, and all the respondents who swore in support showed that it was bacchanal at the center. People cursing people. Every day, people cursing people. They are dissatisfied. There are people calling people thief. You want thief the election?
Well, I think when I read the affidavits, there seems to be a misunderstanding on all sides as to what is to occur in a Section 84 process. And I think maybe if persons had sat down rationally considered what had to happen at a Section 84 process, bearing in mind that there's a Section 82 process, maybe there would not have been such confusion. Clearly there was confusion. It's very unfortunate that, to put it mildly, that there was such confusion. But maybe if there was an understanding of what the section really required persons to do. And when I look at the affidavits also, I don't want to sound as though I'm criticizing, but it tends to suggest that there was no uniform methodology that applied to all 9 districts as to how we're going to get this thing done. So it was left in a kind of a way to each returning officer to kind of figure it out. So long as you came up with something that nobody quarreled with, just figure it out. That's what it seems to suggest. That's what the affidavit seems to suggest. Whereas maybe there should have been a system. This is how you have to do it. There's no ifs, ands, and buts. When it comes to Section 84 and persons have to be present, first thing first, this is where they're going to sit. And this is how you're going to behave. And this is what, kind of some protocols. It doesn't seem, from what has been presented to me, that any of that was present, and maybe all of that has lent to the problems that occurred. Anyway, Mr. Boston, I think you've made your point. Is there any other thing before I ask you one question?
No, I just have the England cases from India, which dealt with the same. As I said, the same approach was taken by the Indian courts in Gayan Singh and the district magistrate. All India Report 1975-315.
This is on the mandatory directory?
Mandatory
All right,
directory.
I'll read it through, Mr. Boston. It's fine, thank you.
There, I don't wish to say anything unless you wish to ask me difficult questions.
The point about the res judicata, I'm just not getting it. I'm sorry, because if it is that Justice Singh's order cannot be revisited as being res judicata, well then all of this has been an exercise in futility. I didn't have to put aside all these judicial hours to hear the case.
Well, my argument is there for consideration by this court.
So you want me to accept that it's res judicata?
It is my view, it is. But
if
you don't agree with me, then of course you can knock me down and say it's unmeritorious.
Sorry?
If you don't agree with me, you can say it doesn't have any merit. But what I'm saying is Mr. Allard went to Justice Navindra Singh and made an oral application.
Yes. And got what appears to be a final order.
I don't think it can be characterized as what appears to. It is a final order. And those were your statements when you ruled on Sunday.
Okay.
Those were your observations.
But there was no, my understanding of these kinds of cases, because it's not unusual, just a little bit of education for the public out there, that one can make urgent oral applications to the court. A court can sit at any hour, any time, anywhere. So it's not like if it was an aberration. It was not. So an urgent oral application was made, and that's why directions were made, as they usually do in all these kinds of cases. You have to file your documents to back it up. Because if you don't file your documents, it lapses. So they had to file their documents. If it is that you are contending that the injunctions granted by Justice Singh is in a final order, then we didn't have to bother with the written application. We didn't have to bother with the arguments, because then his order would stand. And his order says, comply with Section 84.
I think there is appeal was filed this afternoon.
Sorry?
Now, Section 10 of the Judicial Review Act says it has to be interim.
Yeah, but you argued for it to be final and it is res judicata. So Sunday, when Mr. Mendes said, okay, let's just say it's an interim order pending the hearing determination of this application. You objected, and I could not understand. I'm very sorry, Mr. Boston. I just could not understand the objection, because pending the hearing and determination means that this court could go either way on it. But if you hold on to the position that it is res judicata and that you can't go back to it, then it stands, and that's it. I mean, if you want, you can change your position. I'm not.
Having regard to the way you're leaning, I wish not to pursue that point.
I think that is best. Thank you.
But what is interesting, madam, even I think those orders were dissolved, this representation to Justice Singh that I will file documents within 72 hours. One expects him to file the fixed date application, the affidavit in support of the fixed date application, without notice application, and an affidavit in support of that without notice application, to continue the process. But no, without notice application was filed.
That's because of how the order was framed. It was because of how the order was framed. The order should have been framed a bit differently. Let me just put it that way. Mr. Mendes did say that he would concede on that point. Anyway, we're moving on. That's water under the bridge.
Yes. Will you?
Good. Thank you very much, Mr. Boston.
Just a couple points very quickly.
Just please turn on your mic.
Sorry. Mr. Boston is seeking to resile from the position that he has put in the evidential position he's put in his affidavits by resort to the presumption of regularity. Now, my lady, the question as to whether Mr. Mingo did the adding up himself or through somebody that he was authorized to appoint is one that was raised by him. He, in evidence, told us exactly what happened, and he made it very clear, if you look back at the words that he used in his affidavit, that the adding up from the statements of poll was done in his absence by Ms. Miller and other clerks. He has said that very clearly. So there's no room for a presumption of regularity anymore. Remembering, my lady, that this being judicial review proceedings, the returning officer whose decision is under challenge owes a duty of candor to the court. That's the Huddleston principle, my lady. He must be open, he must put all his cards up on the table, and therefore we are to assume that when he says that he was absent when Ms. Miller did all of these tabulations and inputted the information into the computer through her clerks, that is what he did. And he then says that at the end of that process, he was ready to make the declaration. This was by 7:30 on the 4th of March. That's what he said is in evidence. So he had already decided, in other words, by the 7:30 on the 4th of March, that he was not going back to adding up the statements of the poll in the presence of the parties. He already decided that by 7:30 on the 4th of March. And to the last point, my lady, is that substantial compliance? I would imagine that my learned friend in effect is saying that if you are required to come to work from 8 to 4 and you leave at 12 o'clock, and your employer says, well, I want to dismiss you for non-attendance, you say, well, substantial compliance. I was there from 8 to 12. Or if Usain Bolt is to run the 100 meters, and he says, well, I finished 50 in 4 seconds. Substantial compliance, I win. With all due respect, my lady, it may have been we may have been able to grapple with the argument if there had been 90% compliance. Then you can have an argument, even though you may not succeed in any event. But not with less than 50% compliance, my lady, in something as important as this. That cannot be substantial performance. Much obliged to you.
Yes, sir.
Kindly bear with me. I'm just checking on the matter so I can fit this in. Kindly bear with me. I'm just checking on the matter so I can fit this in. Very well, I'll fix this for 2 o'clock tomorrow afternoon for decision. Again, it may not be the full decision, but I would like to render a ruling so that there's not much more delay. Thank you very much. 2 o'clock tomorrow afternoon. Martin.
Crux of my argument is simply that there was substantial, if there wasn't 100% compliance, there was substantial compliance. And the authority says if the provision is directory, then what happens? Substantial compliance will make it not invalid. And the substantial compliance, the Chief Justice seems to mischaracterizing this thing. Substantial compliance does not have to do with the number of ballot boxes or the number of statement of poll that left to have been checked. It has to do with conduct, and that is what Mr. Mingo did. You may have 558 ballot boxes to come, and they might only be able to bring 20% of the votes. They might only be able to bring 20% of the votes. And those that went before, because of the area that they came from, could have given you but 70% of the votes. And you're going to say, that may not. How can she measure? It is only the issue of conduct has to do with substantial compliance rather than the issue of ballot boxes. Boxes or statement of polls still to be come.
Could you elaborate on what you meant by Mr. Mingo's conduct in this?
Yeah.
What is meant by Mr. Mingo's conduct in this context?
Well, the evidence from everybody that Mr. Mingo, from Monday night after the statement of polls came to the command center, he worked until about 3 a.m. Tuesday. He came back Tuesday morning about 9 o'clock and he worked again. And this is the evidence of everybody. He worked in the night. He came Wednesday again and he worked. And then there was bacchanal in the place. PPP people, Kwame Cousin. People call him Valda Lawrence. She want thief at the election. So what must he do? He doesn't have to come and sit with them and go through a process disagreeing with them that this is what I have recorded from the statement of polls that was sent to me. He has to rely on those statement of polls that were sent to him from the various districts in Region 4. If there are discrepancy, as he called from his spreadsheet, and it doesn't correspond with theirs, he has to abide by his statement of polls. And the statute gives them a remedy if they don't agree with it. Come to section 84.2 and ask for a recount.
Mr. Wilson, could you address
What I expecting? I will feel that if she rule against us, how will I describe that? No, let me not say this.
Well, Mr. Sunday suggested, Mr. Douglas suggested in the court that the final tabulation was done by Ms. Miller and not.
There's no evidence to that. All Ms. Miller
and go through a process.
Tabulation was done by Ms. Miller
And not Mr.
There's
Mingo.
no evidence to that. All Ms. Miller have complied with 84.1, and under 84.1 he is obliged to do the
Mr. Mingo was away, having been taken to the hospital on Tuesday morning.
But there's only
Who
for short-
subsidized for him while he was gone? Substituted for him when he was gone.
I can't speak to that.
Did that person tabulate any of the statement
I
of
can't
polls?
speak to that. I can't speak to
Could you
that.
say why the declaration wasn't made the night if it was already ready at 7:30 as against 2 p.m. the following week?
Give them an opportunity to come again. But was Robbie Rosas, Kwame, Ransom, all of them, Anil, Jadio, the whole team ran, broken down the door, the chairperson. How? All of them, Anil, Jadio, the whole team ran, broken down the door, the chairperson. How in such an atmosphere can you move the go home, declare the results, and let them seek the remedy?
Did your client spoke about his safety, fears for his safety?
No, that wasn't any material issue.
But in the court we heard that there was some contradiction as against what Ms. Myers was saying and Ms. and what
I haven't seen any contradiction. Probably the Chief Justice has
Whose name the injunction was granted. He's being represented by Douglas Mendez, Senior Counsel of Trinidad, and Anu Nandalal. Mr. Nandalal, just come this way. Just come this way.
You need to come in closer. Thank you.
Yes. You can now speak with Ms. Anil Nandal, one of the attorneys for the applicant. Ms. Nandal, could you comment on why you think your arguments were solid this afternoon?
Well, we had in affidavit evidence what transpired during the process that was supposed to take place pursuant to the provisions of Section 84 of the Representation of the People's Act. We had at every stage of the process, when it began by Mr. Mingo, when he got tired, then when he was supposed to resume the following day at 9, but he could not have resumed because at 11 a.m. he was escorted out of the building, and all the drama that followed with the officer who ties for him, and then the feeling tired of these two persons and other persons attempting to substitute for them, and the abortion of that process as well, and the introduction by Mr. Lowenfield of a review and update of what was verified and what was not verified. We have all of that before the court. So the court had a very complete picture from our affidavit of what transpired. On the other side, the court had affidavits from James Bond, from Aubrey Norton, first of all, and Adams, two candidates for the PNC, AP and ALC. The court correctly disregarded them because they related to Region 3. They had nothing to do with Region 4. Then you had James Bond affidavit. I don't know what that said. That obviously didn't say anything of moment. but importantly, Mingo's affidavit was there, and Mingo corroborated what we said, that he didn't complete the exercise. Mingo introduced a staff member as informing him that the exercise was completed. This staff member, as we were able to establish to the court, was not an authorized staff member, first thing, to be conducting the exercise. But secondly, we had case law authorities to show that the returning officer is the one who is tasked with the responsibility by Parliament, and only him personally can discharge it. And though he said he discharged it through his agency, his agents, he admitted implicitly that he didn't discharge it. He didn't complete it himself. And the affidavit of Bond and, who was the other one? Bond and Myers and Nicola Trotman both accepted and admitted in their affidavit, either intentionally or unintentionally, that the process was not completed. That forced Boston to argue the issue of substantial non-compliance, and his arguments were disastrous, honestly. But aside from that, the issue is that the exercise has to be completed. If Parliament wanted half of the exercise to be completed, Parliament would have done so. Parliament said that the RO must ascertain and must adopt the figures from the statements of poll, not a percentage or a substantial number of the statements of poll, but all of them. And in the presence of political parties, and they list other persons and any other persons permitted by the RO. The RO at the beginning of the exercise permitted those people who were there, including the international observers, the parties, the congregations, and persons to assist them. You all were there, the world saw that. So the issue of unauthorized personnel being present is a moot one and not even relevant to the proceedings.
But he's also argued that given the conditions at the time with the ruckus and so on, Mr. Mingo had no other choice but to go ahead and declare the results in the context of what he termed conduct.
Unfortunately for Mr. Boston, Mr. Mingo didn't say that in his affidavit. Mr. Mingo didn't say that. And that's why the judge was drawing to his attention where in the affidavit evidence from Mr. Mingo is that stated. Mr. Mingo said that he was tired one time, then he was sick, and that he relied on what Miss Miller, said to him. And Miss Miller didn't make those depositions. Those depositions were made by Trotman and Bond and Myers, I think. But that is neither here nor there. The exercise has to be completed. The legislation doesn't say that if there's a ruckus or there is an objection, it means it must be stopped. And that can amount to satisfaction of the legislative requirement. In other words, if there is a ruckus, there is an intervention, if there is a boiling down in the place, that will enable the RO to call off the exercise. It doesn't say so. It doesn't say so. And what caused the ruckus? Let us assume that they were ruckus. What caused the intervention? The intervention was caused when the spreadsheet was being used, which spreadsheet did not reflect what was on the statements of poll. That was when there were attempts at interference, when Mr. Lowenfield didn't want to complete the exercise. Everyone knows that. Everyone was there. Everyone saw that. It was not that anyone engineered these things so as to bring the proceedings to an abrupt end or to break up the proceedings. They were done to object, to get compliance and complicity as laid down by the law.
Mr. Nalal, what do you make of the judge's comments that the provisions under 841 were not made pellucid, not only for Region 4, but any other regions? Nobody sat down and said, this is what we should do.
Well, first of all, you had no problems with the other regions. And the other regions did exactly what Mr. Mingo attempted to do. And I have no doubt intended to do until something went wrong. the returning officer of Region 4 was not permitted to function freely and voluntarily. That's my view. He was acting under tremendous duress, pressure, and political directions. And they did not. First of all, the RO should not have been situated in the same room with the Chief Elections Officer and the whole GECOM apparatus. That's the first mistake that was made. And what it does is supposed to be checked against the CEO records. They are not supposed to be in the same building where there is interference and contamination. So to situate the RO in the same building was completely wrong in the first place.
Do you have
And
any
that's
evidence?
the hope we learned
Do
from.
you have any evidence of political interference?
I am saying that. I am saying that.
Oh,
I am saying
Do
that.
you have any evidence of
The RO
political?
is still under duress. in my
Yeah,
view.
You refer to political
in your
influence.
influence.
and
Do
all
you have
that.
any evidence of that?
Do you have any evidence to support
Of what?
Political influence.
political influence
of the RO.
on
Oh,
the RO?
The world saw that. I don't have to say anything.
No, no, but
No,
you
but
were making a
you make-
statement.
that's why I
You made a
said
statement.
I have said
How do you
that.
expect the judge to rule tomorrow, Mr. Nandala?
Look, it's a simple issue. This section 8 was section 804 of the Representation of the People's Act complied with. No, it was not. The whole world saw it was not. And all the learned judge I was asked to do is to order that it be done as Justice Desiree Bernard was asked to do in 2001, which she did. It is no big issue here. It is just that the process is not being allowed to be completed. That's the problem. The learned judge I was asked to do is to order that it be done as Justice Desiree Bernard was asked to do in 2001, which she did. It is no big issue here. It is just that the process. Problem.
That the ruling tomorrow may not be the Camp ruling, but she wants to get on. What do you expect?
No, it means that she will. I interpret that as being that the learned Chief Justice will not have her entire written judgment available, but would be in a position to give an order.
Enough to get
To make the order. I think I get that. I get that as being what she intended to say, or what she wanted to say.
Mr. Nandala, as someone familiar with the Region 4 electoral process, could you say with any certainty that the statements of poll that were released by your party online are really the complete set of polls representing all of the polling stations in Region 4?
I would think so, yes. I didn't go through every single one of them. We have different persons in our party performing different functions, and if my party says that that is the sum total of what they have, I am going to accept that.
As a true reflection of all votes cast and counted in Region 4?
Yes, yes.
Sir, could you say if the PPP would have shared their data for
I am not involved in that part of the engagement. You can ask other persons who have custody of the statements of poll that
Mr.
question.
Nandala, are you prepared to, not receiving a favorable verdict tomorrow, move forward with this?
Things are moving so quickly that we have to think things out, and we will cross one bridge at a time. We can't multitask at this time.
But is an appeal possible during the 15-day time frame within which?
That is another hurdle that we have to face, whether that 15 days is mandatory, whether it's directory. That's also a live issue that we have to consider. I have no doubt that the judge is aware of that. The judge is quite an informed judge.
Thank you.
Thank you very
Thank
much.
you.
Thank you.
There you had it, Mr. Nandalal, who is lawyer for Riaz Holadar, the man who has filed a suit and in whose name the injunction was granted. Chief Justice Roxanne George will hand down her ruling tomorrow. She did say that it will not be the full ruling. We're coming to you from the High Court.
Statements of poll for region number 4 were tabulated in the presence of political party agents and observers, but that process was eventually abandoned. Mr. Mingo, the returning officer, in evidence presented to the court, suggested that he at some point on Wednesday he had handed over the process to someone called Miss Miller, a senior clerk at the Guyana Elections Commission. And so the Chief Justice said that she will give her ruling tomorrow at 2 p.m. She will have to rule whether the returning officer for Region Number 4, Mr. Claremont Mingle, will have to go back to the process he started, which was to tabulate the vote count in Region Number 4 from the statements of poll in the presence of party agents and observers. As we have been reporting, the argument by the returning officer in the person of his counsel, Mr. Neil Boston, was that he complied substantially with what the legislation required, even though more than half of the statements of poll were not tabulated in the presence of party agents and observers. So the judge will have to make her ruling. She will do so tomorrow at 2 p.m. And of course, we will hopefully bring to you live that judgment when she reads it. Once the audio is available. The Chief Justice has been, we have to mention, one of the most cooperative judges in accommodating the media here. She has put a speaker box outside so we can record the audio for you and bring it to you live. It was the same thing she did when at the end of January she had ruled in the no confidence motion. She obviously understands the importance of the cases before this one, and she wants to be able to let the public hear it as she delivers it. So once that setup is there tomorrow, we'll be able to bring you that judgment live. For now, I'm Neil Marks reporting from the High Court for Newsroom on eNetworks.